Thank you, Viren.
Huge round of applause. Thank you so much, Dinesh bhai. I think this was very illuminating and a fantastic keynote. Before we move ahead, I would very quickly like to skim through the last 2 years of various new initiatives. So we took up KCF 2.0, and I just want to very quickly in 2 minutes summarize some of the initiatives and programs that we did as a part of that. So we did 17 programs since March 22. We still have a couple of months to go. So we started with a Rhythm Cafe, which was a booming introduction to the 2.0. Next, this was our big one, which was the 10x seminar, 10x story. Next. Change management in the VUCA world. So we had a fantastic panel with some very big names, followed by the flagship event, which was the 10x Growth Summit at Lonavala, and this was a mega success. Then we had a whole session on LinkedIn, how to win high-value clients using LinkedIn. SMEs funding option, that was the next program we had in September. After this LinkedIn, we had requests for actually to create a masterclass with Neeraj Shah, so we actually did that. Next. We invited Jagdish Sheth, global, globally known professor for growing importance of India in the New World Order, and we are seeing all of that play out actually. We worked with Wagad graduate to do this future business revolution in retail. Last year in March, we had this in Lonavala again a 2-day workshop, which was a GAIN workshop, Growth, Acceleration and Innovation program, which was a part of the whole 10x theme. Next, we had a networking and entertainment dinner night at Matunga Gymkhana. Again, with Neeraj bhai, we worked on ChatGPT, which was the new thing coming. This was the second version of our second edition of the whole 10x Growth Summit. This year, when I'm saying this year, it was 23, so June 23. Again, a mega rocking success. We worked with on the health and wellness in day-to-day life. Next. Followed by again another night of entertainment and networking for our members. Last program we did was Strategy Shastra with Kirit bhai being the keynote and Manan Vasa and Kirit bhai taking the whole program. Yeah. I would invite people who are not members to join us. You can access us at online membership form can be accessed at kcfindia.in. Thank you. So with that small thing, I'll like to call our panelists, and before that I'll like to introduce our extremely esteemed panel over here. So first up we have Toral Shah, who is a partner at GBCA Associates. And Toral specializes in transaction and business structuring, direct tax advisory and representation, and also in estate and succession planning. She also heads the transfer pricing practice at GBCA. And she's a regular contributor to various professional journals and member of, in fact, the General Committee of Chamber of Tax Consultants. So thank you, Toral. Next is CA Rajesh Dedhia. He's a vice president at Universal Trustees Private Limited. He's in fact been with Universal Trustees for more than 3 years, out of a 20+ year long career, during which he had a major stint with ICICI Bank in various roles. Also in the past, he's been, so apart from being a private banking and corporate banking banker, he's also been providing financial consultancy, credit structuring, facilitation. Most importantly, and relevant for our today's topic, he's conducted multiple webinars for senior executives, large corporate houses. And under the guidance of Universal Trustees co-promoter and mentor Dilip Choksi, he has been advising multiple family-owned businesses, business houses with various apt customized structures aligned to their objectives and wish lists. So that's a very direct correlation to our today's topic. And he has been instrumental in providing solutions for complex family compositions, business ownerships, foreign citizenships, tax residency cases, etc. So extremely fortunate to have Rajesh Bhai here. And last but not the least, Rajat Datta. Dinesh Bhai, I think, alluded to Rajat at least about 5 to 7 times during the conversation. So he's the founding director of Inheritance Need Services Private Limited, along with his wife Devjani. He's again a chartered accountant, company secretary, and a law graduate. He's had career with RBI and more than 3 decades in various roles in financial services and corporate and legal functions. Most importantly, I think the business that he has built is around directly around inheritance needs that we all have. In fact, a lot of procedural parts and all. So I will not steal the thunder from him. I would, before I invite the esteemed panelists on the stage, very small point that I would like to mention. Normally, we earlier had a practice of giving mementos to the panelists or speakers, but this practice we've done away, and instead of that, KCF actually takes that amount and donates it to a worthy charity. So, sorry, we are not able to give you the mementos, but we are using it for a good cause. So, with that, we are already running out of time, so I would love to invite our esteemed panel on the dais, and Dinesh Bhai, who is the moderator of the panel.
Hello. So as I said earlier that we're going to have a panel discussion and then post that your questions, which are going to be equally important because we learn a lot of things from the questions only, and that is going to be really interesting. So I'll straight away start with the questions for each one of them. We'll ask them to. So should I start with Mr. Rajat Datta only? So Rajat Bhai, generally we have talked about nominations and joint holdings and all that. So basically, what is the status of nominee? That is also we have discussed, but if you have anything to supplement. So who inherits your assets? Nominee, joint holder, or someone else? And is joint holding preferred over nominee, or both have their own significance?
Thank you, Dinesh Bhai, and thank you for an august audience here this evening. First of all, I think the question is going to deal that Dinesh Bhai has posed before is only with regard to financial assets, or as we call it in a layman term, movable assets. Because in case of a nomination, as he rightly pointed out in his presentation, he is only a custodian and a gatekeeper or a warehouse keeper, except in case of insurance, which as per the new amendment, he has beneficial interest. Just one change from what we discussed. This new amendment has come in because the insurance is the only financial asset. And I repeat, insurance is the only financial assets which requires insurable interest. What is the meaning of insurable interest? It means that if I have taken an insurance on him and he's the policyholder and I am a nominee, I can be a nominee only if I have insurable interest. Means if he dies, the loss to me is going to be much higher. And that is why this clause has been put in. I will give you a very real example. One of our clients wanted to give 25 lakhs to his servant who has been with him for 30 years. The best way of doing it was to take an insurance policy so that he can get an annuity after the client dies, but he could not take an insurance policy because there was no insurable interest with the policyholder and the person who was going to pay. And that is precisely why this clause has been put in. But one more correction to that. As Dinesh Bhai rightly mentioned, it is only applicable to blood. Parents, spouse, children, he rightly said all the three categories. I repeat, parents, spouse, children. However, if I have taken a policy on someone and made him a nominee and I die, then my spouse or my child gets it. But if in my will I said that he should go on charity, then though he is the beneficial interest as a nominee under the new provision, the will supersede, and he then has to give it to that charity. So that's
So here you are trying to say even the first class one also
he is the beneficial interest as per the new policy, so he gets the money. But the will superimpose, and later on he has to pass it on to the charity. So that's the essence, because why we said is the nominee is in case of a nominee, as per the banking, as per the demat, he is only holding it in temporary interim stage. Here he becomes the owner. I repeat, he becomes the owner, but because the will precedes, and will, as he rightly mentioned, is a wish list till I am alive. After my death, it becomes the will. And when it becomes the will, he will take it as the owner, and then he will pass it on to the concerned bequeath. This is the change. That's about it.
So this is something new which I am learning.
सर ऐसा नहीं है
क्योंकि तो 2015 का अमेंडमेंट का मतलब क्या हुआ कि वो जो कहते हैं कि बेसिकली वो नॉमिनी जो करते हैं नॉमिनी सुपरसीड्स इन
If you
दैट
see
केस
the amendment, it says heirs. It does not use the word beneficiaries. He will become the beneficial interest and have a superior than heirs. Means अगर मैंने will नहीं किया होता तो उसके पास रह जाएगा. Then हिंदू सक्सेशन एक्ट में heirs को नहीं मिलेगा. But because मैंने will किया है और मैंने बोला कि ये अमाउंट चैरिटी में जाना है, hence he will then give it to charity. The word is only heirs. They have not used the word beneficiary. So that's the reading under the line.
Okay.
That's one part. I think he's rightly pointed out that a joint owner or a joint holder is on demise. He becomes the surviving joint holder or surviving joint, and hence he continues to be the owner. But I have a very peculiar case. I have a demat account with my friend and I have died. In the nomination of my demat account, I had made my daughter as the nominee and he had made his son as the nominee. Now, when I died, by default, he has to open a new account, just academically. He has to open a new account, and he may or may not say or respect my daughter as a nominee share. He will say, you show me that your dad left behind a will which says you the nominee, or you prove it as a Hindu Succession Act. So rightly, your question has taken all the aspects of a joint owner, I call it the surviving joint owner, and then of a nominee and how it has to be dealt. So I think in case of other assets, it's pretty simple, because what happens in demat also happens in mutual fund in physical form. But let's take a little skewed example of how will this behave, this particular joint and nominee behave in case the nominee has died before the owner. So the nominee has died and the owner is alive, and the nominee in his will had given it to whatever I own, will give it to my son. But a nominee cannot appoint the owner because the nominee is not an owner. If nominee has died before and I as the owner have not changed the nominee, and if I've died, That's it. My succession law will apply.
Correct.
That's about it.
Thank you. Thank you, Rajat bhai. So, Rajesh bhai, we go to you. Since you are managing so many trusts and private trusts, so technically, we've just talked about a little bit on private trusts, but what is a private trust? How is it different from a charitable trust? And under what circumstances and for whom do you recommend formation of a private trust?
Sure. Thank you. Thank you for that question, and thank you, audience. First of all, this subject could be emotionally taxing, so I'll be thoroughly practical about it. Emotions, let's keep it aside. You saw the Hindu Succession Act, you saw the complexities. Now, when I speak about trust, the first thing which comes into my mind is the charitable trust. This is my school, so it is again a trust. So, educational institutions, most of us would be religious, connected. So these are different trusts under the same law where public at large are the beneficiaries. When we speak about the private trust, this is where I decide who are the beneficiaries and not the law. Just to give you an example, I may say my son is a beneficiary. The spouse of my son could be a beneficiary after 30 years of living together. Pun intended. And maybe my kids would be the beneficiary thereafter. Now, a private trust is a very, very flexible structure as such, where I can have complete power as a creator, technically called settler, where I can have a revocable trust. Whatever is owned, I can make any changes. It is like I am still at the driving seat. I can take a decision, I can change the decision as I like. There could be, on the other hand, irrevocable trust, which means once I have created, there are minor possibilities, and I use this word very, very carefully, minor possibilities to make certain changes, provided certain things are doable. Then comes the question of beneficiaries, where I can have specific beneficial interest. Let's say if I am creating for my wife and 2 daughters, I may say my wife may get 20%, my 2 daughters get 40-40 each. Or I can also start creating a discretionary trust, where I may empower the trustees of the trust to decide whom to give, what to give, when to give, how much to give. So that's the beauty of the subject. It is like a will is like a blueprint. A private trust created during the lifetime is like machinery. You see it running, and all of you are the corporate, so I'm sure you would have machineries running at some point in time, and there would be a teething issues. So if those teething issues are settled during your lifetime, that much safer, we assume that it would go on the autopilot after you. Now, for whom it is important? Of course, it is, I'm saying, one is where, at what price it is financially feasible to create a trust. I leave it to you all, because that's not too much of cost of running a trust. But depending upon the family's composition, depending upon the expectation versus reality mismatch. See, we all talked about everyone is equal by law. And my last will supersede over all my previous wills. So after after the author is no more, someone will have to prove which was my last testament. And that could be notorious at times. It could be lengthy, it could be contestable. And hence, if by some manner I can reduce the weight of my will, today I own 100 rupees in the form of real estate, financial assets, sometimes operating business ownership, sometimes perceived ownership. As you rightly said, made mujho jaye. Boss, legal ownership supersedes. So, I'm sorry for that kachi shabd. So, I'm saying here that, depending upon what is the asset class, what are the beneficiaries, and what I intend to achieve as an objective. There are some of the cases where we have seen that the next generation is spend thief. There are some cases where we want to avoid ill effects of wealth. Too much of wealth, reaching out too much early could be an issue. In some of the cases, Just by an example, a brother and sister can have two different types of asset class investments. One can invest into equity, one can invest into debt, and both be happy with the return of investments. But at times, some of the assets has to be owned jointly, especially your ownership of businesses, where the stakeholders are not just your family, but also your employees, suppliers, customers, so on and so forth. So wherever you feel that possibility of my will is there, that it might get challenged, there may be a delay in transitioning of the asset, that is the case where I feel the trust is the answer. And unlike an HUF, you can have more than one trust also created during your lifetime. Last but not the least, for the special child. I think that subject is very near and dear to our promoters also, where giving the assets to a special child is an error by the parent. Ideally, there has to be a trustee to the trust, which is where the assets are being kept, and there is a caregiver who's been enough financially funded. So I think the structure offers so much of flexibility. And all this I said, these are the objectives or the achievements which are intangible in nature. I cannot quantify the money saved by not getting into or money saved by maintaining the family harmony. But if India was to introduce inheritance tax, that could be one area where a trust created before demise. Inheritance tax, in a simple word, is that on death, if it is going to the next generation, there could be possibility of tax. And there has been deficit during the COVID times, where again this talk was re-emerged that India should introduce this tax. I think most of the ultra HNI, they have created this structure. They like this structure as private trust. And hence, that could be a solution. And it is not will or trust. It is or but Hindi wala. So you always have will and you will also have a trust, where some of the assets are parked in the trust. You reduce the weight of the will, and thereby some of the possibilities of contest also reduces. Over to you, sir.
Thank you, Rajesh bhai. Yeah, I think it makes sense what you're talking about a private trust, because generally the thing is that we feel that trust will come into play only if it is 50 crores or 100 crores plus, and it could be only for promoter-driven companies, and that is where people would be more interested in the trust. But if you feel that, yes, for special child needs or otherwise also, normally even if having a smaller wealth also, trust can definitely have its own advantages. So Toral, coming to you now, HUF also, as he mentioned, HUF has to, is a mode of succession planning. It's always there, and we all have our own HUFs. So now, has HUF as an entity outlived its utility, and why? And what are the ways to wind up an HUF? And one more question which I'll add with it, rights of a woman in HUF of father and HUF of father-in-law and husband. So technically, when we are talking about that, okay, how would you treat those, an HUF as an entity? Because technically, we always say that there is a tax saving in the HUF. But otherwise, practically.
Yeah, thank you, Dinesh bhai. Good evening to the august audience. HUF as an entity is something we have lived with for ages, and Hindu undivided family had its own importance. We have lived together as joint family, uncles, aunts, cousins together, living in a single house, having a joint kitchen, and it was a very close-knit fabric of family values. Over the years, we have seen that the HUF has now kind of disintegrated. We have nuclear family system predominantly. Even within the nuclear families, you have one son who shifts to US while he still undergrad and never comes back, and then another son living in India, or both have shifted to US. Now, under this scenario, the fabric that was binding the family members together has somewhere lost its strength. Coupled with that, if you consider the amendment of the Hindu Succession Act that has come, where women, or rather daughters, have also been given the same rights as co-partners. That means earlier the thought process was, once the daughter is married, never it was thought that she is entitled to receive an equal share as her brother. I think anybody whose will I make who is of 60 plus of age Most of the time, he says, "Nee, daughter ne kahin nathi apvanu. We have given her enough in marriage. Everything should go to my sons who are managing the business." Now, that was the thought process, say, 20, 25 years before. However, after the amendment of the Hindu Succession Act in 2005, law has given equal rights to the daughters. So now what has happened is, the HUF, if it has substantial assets, the grandfather's HUF, which has substantial assets, now suddenly, after the amendment of 2005, you have daughters who are already 50 plus of age, realizing that I have a right in the family assets which are held in the HUF. Now, this has kind of, unsettled, while I as a woman have no problem with women getting anything from her parents, but the fact remains that this was not the thought process. This was not what was intended by the family. This disturbs the overall relationship matrix of the families. Second thing is, now because if you have a three-generational HUF, say the grandfather's HUF, where the uncles and aunts are co-partners, and now you have the children of those uncles and aunts who are co-partners. So as you know, in HUF, by birth, a person becomes a member of HUF automatically. There is no procedure that has to come into play. So anybody born into the family becomes a co-partner. So now what happens, these cousins who are the third level HUF members are actually, say, maybe staying in different countries. The family is not so close bound. Then the HUF properties, which have to be jointly managed by these diverse family members, becomes a very complex phenomena. If somebody is an NRI, his taxation in, for example, US becomes complex because he's member of a Indian HUF. So all these uncertainties of HUF, also there is one question, can a co-partner will out his share in the HUF? Now within the three of us, we have a ratio of 2:1. One is saying no, and two of us are saying yes. So there are many such questions in an HUF where the answers are not very clear. So there is a recent decision of a High Court where third level female is claiming that she can be co-partner, a very recent decision of 2023. Suddenly she has realized that I can be the karta of the HUF. Now all these years, the grandfather's HUF was managed by the male members, and the aunt today says, I am the eldest third generation, I should be made the karta. Now in this situation, whether it is advisable to continue for the HUF, because I see my clients are very fascinated, 2 lakh rupiya no faido che every year in taxation. Now whether the 2 lakhs rupees is important, or the value that you have in the HUF should not be eroded because of disputes, differences in the family members, whether it is the right time to discontinue the HUF when the patriarch or the vadil of the family still is in the driver's seat, his decisions are being respected by the family members, and a partition can be amicably achieved to the satisfaction of all. When you lose that patriarch, there are going to be diverse views. Everybody will try to look at his interests, and then the partition or the closure of the HUF can get very messy. So we are of the opinion that if there are already HUFs with 3 generational members, it is ideal that you close down the HUF to avoid such complications. So, and even one more complexity that is there in HUF, when minors are members of HUF. Now, legal fraternity itself is divided, that if an HUF which has a member and which has a property which needs to be sold, whether you need a High Court permission. Now, different lawyers are giving different views. Some say, yes, you need to go to the High Court to sell the property. Some say you do not need to go. Now, any buyer of property is very wary of buying a HUF property. I'll explain this by a practical example. We have this example of Vijaypad Singhania, not the recent controversy, the old controversy with his elder son. Now, the elder son had entered into a family settlement and he had given away his rights in the Indian ancestral or family assets. After the elder son's children became major, who were there all settled in Singapore, they came back and said, my father could not have entered into this settlement because in the joint property, we as co-partners also have a right. So after many years, there is a claim by the grandchildren and the HUF property, whether father could have, in fact, they have sued their own father and mother and also the grandfather, that the father should not have entered into this settlement because he was not entitled to do this settlement, we being co-partners. So they can challenge it after they become major and within 3 years of their becoming major. Because of all these complications, people do not want to buy properties of HUFs. Now with all these complications, we all need to consider whether we need to still continue HUF and save the 2 lakh rupees per annum, or we need to discontinue the HUF. So this was one thing on whether to continue the HUF. Second question on what is the right of women in HUF. So with the amendment that came in 2005, a woman becomes co-partner in her father's HUF. What is co-partner? Co-partner is a person who can ask for partition of the HUF. So if the daughter wants that my father's HUF has 5 crore rupees, I want to dissolve the HUF, she can give a notice that please partition the HUF and give me my share in the HUF property. So that is the right the law gave her in 2005 in her father's HUF. Now coming to the HUF of the father-in-law and husband. In that case, the right of the woman is a little lesser than in that father's HUF. In the in-law's HUF, she is only a member. That means she has a right to maintenance. She cannot ask that partition the HUF and give me something because otherwise she is not entitled to a share. However, when the HUF is partitioned, she is entitled to a share equal to her children. So that is the difference between the woman's right in her father's HUF and the woman's right in her in-laws and husband's HUF.
Okay. Anything that you need to supplement on this, Rajat Bhai? Rajat Bhai, insurance, you already mentioned that this thing. Now, if you have to come to a bank account, would you help us in NRE, NRO bank accounts? Because there are a lot of people who are staying abroad also. They have their own family members who have their NRE, NRO accounts. But as a resident over here, can I become a resident as a joint holder in the NRE account or NRO account or FCNR account and all that? So what is your view on that?
Yeah, so you, a resident Indian, can become a joint holder in an NRE, NRO and FCNR and operate it with a power of attorney only. That's the restriction. So you can operate it with the power of attorney only. However, you can be a joint account holder. Most important is the structure of the NRE, NRO does not change, because the first name of the account holder is that of the NRI. Hence, all the rules and regulations of the money, whether it is coming from Indian sources put there or it's coming from a foreign remittance put here for expenditure here, will have to follow. So the nomenclature, the structure does not change as per FEMA and RBI. What only changes is the operational aspect as wanted, as asked by Dinesh Bhai. One more on insurance. Sorry, I'm going back. LIC is the only insurance company which allows one nomination and 2 successive nominations. Since 2000, when all other 22 private sector insurance companies came in, they have multiple nominations. That is more than one. In some they have 2, in some they have 3. But wherever it is more than 1, you need to write the percentage, similarly that of a demat and a mutual fund. Now remember a case wherein I have taken a policy from a private sector and said that I will make my spouse 80% and my 2 children at 10%, but my spouse dies with me. Naturally, her 80% gets distributed equally among 2 children. Take the same case wherein I have an LIC. I have made my wife as the sole nominee and my 2 children as the subsequent nominees. If my wife dies, then the next subsequent nominee will get 100%.
Okay. Rajesh Bhai, further on the trust, if you have to go, then once the assets are parked in the trust, can the settler control the trust assets?
Sure. So first of all, there's how do I say it? It's in the Singhania families that they have given us 3 good case studies. One which One which has been put by Toral. The other one is where I gift the asset to my son or daughter. I also gift not just the ownership but also the control. And the third one is very recent. So, the key point is that you may choose to alienate the ownership, but the control has to be with the patriarch. There are very negative and nasty things which we have seen, and hence I am saying there is a way to take the control. One control is I can make any changes, I can take back the assets, and so on and so forth, which means I have to have revocable trust. It has its own pros and cons. Or I can have an irrevocable trust where, depending upon what asset I am putting in, depending upon who are the beneficiaries, I have sufficient enabling provisions which I use as and when I need. I call that also as a control. So depending upon what is your objective, depending upon what you are trying to achieve through this, a trust can be formed or structured differently. And you choose to have complete control and on driving seat as a trustee or as a managing trustee. That's also possible. So I can create a trust where I am a managing trustee and I am also a beneficiary. That is also possible. So it's completely
So
flexible.
settler, trustee, and beneficiary.
All three people.
All three are.
We have done it for cases where a single person, people are worried about their vegetation stage, that who will pay my medical bills. Where at least I have one more trustee, but the assets are available. The other trustee would be using that trust assets for my benefit to pay off my medical bills during the cases where I may be immobile or I may be not in my right senses, but not declared death.
Okay.
So completely flexible. What I need, I can be structured. There could be trade-offs between the objectives and control. One has to look at what objectives I intend to achieve and what I can trade off it with little bit lesser control. But I can definitely control.
So here, how do you determine the shares of the beneficiaries? So
Again,
can
from a
it be-
beneficiary point of view, I can have specific trust or a discretionary trust, which means a discretionary trust means I give this power to my trustees, which is again, to start with it is me, but I can always say who are the successor trustees and they also get the same power to decide what shall be the share of each of the beneficiaries. Or I can put it very well in writing that the shares are 20, 40, 40, as I was explaining in my previous example. Again, both has its pros and cons. Many a times a question comes that I want to ring fence it from my professional liability. Now, if you have 40% share in the trust as a beneficiary, a court can give you a dictate that, distribute 40, make good the liability. So it has its pros and cons to have it specific or discretionary depending upon what are my needs. In some cases, it is becoming absolutely crystal clear that I want to do it this way. And there's no way by which a professional liability or a personal liability can hit my family. See, most of us are living with or let me not use most of us, some of us are living with some myth that it cannot happen with my family. I always ask them, when you are buying a new car, why you buy an insurance policy? Are you going to get into an accident? If the answer is no, don't buy the insurance policy. But we still buy because it's mandatory. Similarly, maybe there is no wrong side of being over-prepared, thinking of a scenario which is beyond, where the probability is limited, but still, if it happens, we have seen the long battles, nasty ones, where the family harmony is, destroyed. So, given that logic, we have to again fine-tune the balance, whether I want to have a specific trust or a discretionary trust. And again, as I said, I can have multiple trusts. One could be discretionary, one could be specific as well.
So about the ring fencing which you mentioned, I think, but even the beneficiary's share can be also attached, sort of?
If it is determinable. So let me not use this ring fencing as an object to cover fraud, right? So nothing can cover a fraud. But let's say, given an example, if I have created a trust, I've been using all my income and putting it into the trust where both the daughters and wife is the beneficiary, and maybe my daughter's future lineal descendants as well. And after 10 years, if some liability was to hit to me, I think the wall of ring fencing would be stronger through that trust, because I have alienated the ownership to the trust. The trustees are the custodians of the assets.
Okay, Rajeshwari. Tolal, coming back to you now, what are the rights of children of intercaste marriage between Hindu and non-Hindu under Hindu succession and HUF property? In HUF property, we are talking about both the things too.
So nowadays, intercaste marriage is quite common. We see Hindus getting married to non-Hindus. So the question that does come up is what happens to the rights of the person who does such a marriage? So for example, a Hindu marrying a Catholic, for example, what happens to the rights of their children in the properties? So when a Hindu marries a non-Hindu, the children that are born to this couple, they are entitled to the same rights under the Hindu Succession Act to their parents' assets. So that is undisturbed. So if the father, for example, is a Hindu and dies without a will, the Hindu Succession Act, whatever Dinesh Bhai explained, is triggered. However, the children of such a marriage cannot claim a stake in the joint family assets. The HUF properties, they cannot stake a claim. And secondly, they don't become beneficiaries in relatives' properties. Say, for example, there is a uncle, say Kaka, so father's brother, lives behind estate. And that estate, because it has to go interstate, if it has to follow HSA, they could have been beneficiaries. But they will not be because they are children of an intercaste marriage. However, if that is what HSA provisions provide. So this is limited restriction. They don't get rights in the joint family property and to the relatives' property. But so far as their own parents' properties are concerned, the Hindu Succession Act will be followed.
I think one more question I would like to put up, Toral. Okay, rights of stepchildren or adopted children or illegitimate children in parents' assets in case in intestate succession or in HUF assets.
Yeah.
Because this is also now adopted child or stepchildren is going to become the call of the day now.
Yeah, so coming to first adopted children, so under the law, an adopted child is equivalent to your biological child. So there is no difference under law so far as an adopted child is concerned. So whatever we saw for children means including adopted children. So there's no complication. Now coming to stepchildren. So say for a man marries a woman and she brings with him a child. Now under the Hindu Succession Act, they are very silent about what are the rights of this stepchild. Now, if this man wants to give the stepchild assets, so if Hindu Succession Act, under the Hindu Succession Act, the rights have to come, then the child has to be legally adopted. He doesn't automatically become his child because he has married the woman. So you have to do the adoption procedure under the Adoption and Maintenance Act. Then the child will become similar to a biological or adopted child and the HSA will be applicable to him. In this scenario, if you don't want to adopt formally, then a will is required if you want to give assets to this stepchild. So here the will becomes very critical, otherwise the stepchild, although he may have been living with you for years, will end up not getting much and it will go to the other legal heirs. Now coming to illegitimate child. So while again, the Hindu Succession Act doesn't speak of illegitimate child. Under the Hindu Marriage Act, it is provided that illegitimate child will be entitled to the parent's asset as a normal child. So assets coming from the father and mother, the illegitimate child is to be considered similarly. While one view is that the illegitimate child cannot claim from the joint family property, we have the Supreme Court decision which has said that illegitimate child himself is not responsible. He should not be, given penalized for his parents' actions, and he should be enjoying the same rights as a legitimate child. So the Supreme Court has said that the illegitimate child should be entitled to the joint family property also. So again, this could be a litigious matter. So again, an illegitimate child's rights may not be as strong or equivalent to an adopted or a stepchild. Anything that you would like to add?
Yeah, I surely want to add. So, no child is illegitimate. The relationship is illegitimate. That's what exactly she said.
बरोबर है.
So, Supreme Court's judgment, which she referred to, is the right judgment, which started saying no child is illegitimate. It is only the relationship which is illegitimate. So, what she said is exactly the same thing. Only one difference is that if my wife has come with a child and I married my partner and she had a child out of her earlier marriage, so becomes a stepchild for me, she rightly put it that it has to be adoption. But now thinking from the stepchild's angle, the stepchild has got access to his original biological father. So just remember that. So if I adopt my stepchild as my child, he has got two advantages. He's got my Hindu Succession Act, and he, in spite of being adopted by me, gets the right of his biological father, if the biological father has not willed. That's it.
Okay. Tural, one question on tenancy properties. So generally, most of us, quite of us, few of us have this tenancy, residential or commercial properties. So it could be to either anyone can supplement, complement on that. How do you will out those tenancy shares, and technically whether can you do that, or whether you are allowed, and how does it work, the tenancy laws?
Yeah, so staying in Mumbai, we all are very, this question is very important for us. In Mumbai, we have high value immobile properties which are tenancy assets. And generally the question does come up that, can I will out my tenancy property? So under the Maharashtra Rent Control Act, tenancy, they have laid down who can get the tenancy rights after the demise of the tenant, who is the original tenant of the property. So in that, in case of a residential property, it is the person who is residing with the tenant who will become entitled to the tenancy rights of that residential property. And in case of a commercial property, the person who is doing business along with that tenant who will become entitled to the commercial property. However, now the next question is, then do I need to write anything in the will? So why we say you cannot will out legally your tenancy rights. However, do make a mention of it in your will. That will help your family members be clear. Whom do you want to give the tenancy rights? So that at least you are avoiding dispute at the family level. Secondly, it also gives a guidance to the landlord. So if there are disputes, he can take a cue from your will. Whom do you want to give? So besides the person who is occupying the property along with you, the fact that you have mentioned that in the will also will help in the smooth transition of the tenancy rights. However, legally, you cannot give it or will it out to just anybody. The landlord will only effectively give it to the person who is staying with you in the tenanted property, and you have to have sufficient documents to prove that the person has been staying in that property with you. And for commercial property, you have to prove that you have been doing business with the tenant who was occupying the tenanted property.
Anything that you want to share?
I'm okay with it.
Okay. Here a question is, though will is superseded to HSA, can any member of HSA ask for his share in the property if not given to him in will?
So just remember one thing. When Kasab was a fugitive, he asked a chicken biryani at 4 a.m. in the morning, which was his death wish. Globally and domestically, all courts give full emphasis and respect to a will. But it has to be a legitimate and a last will. So that answers the question. Will is a supreme umbrella document. It overcasts itself over any other thing. Is that right, sir?
Yes. Rajesh bhai, coming to private trust, can it be modified or revoked? You mentioned a few things on it, but and how to safeguard the rights of special need persons in your will? So through your will, how do you mention those things? So does this trust get formed through the will itself, or you form a trust ahead of the will only?
So special needs people are a very detailed subject, but just to answer the question, you can have will or trust created out of will also, which is post your demise, through your will, a trust would be created, technically called testamentary trust. Or you can create a trust during your lifetime. I am fond of creating the second one because it's impossible to write 40-page detail into 3-page document called will. And if you are so confident that the trust needs to be created, why you are giving this liability of creating the trust or authority to create a trust to your executor? Why don't you create it? There's no hard side of it.
Correct.
So if you create it, that much easier it is for the trustees. Because for a special child, please understand, I will need expenses to be paid the very next day. The maintenance bills will start the very next day. Whereas, and sometimes the will takes little while to get probated. In Mumbai, if you own a property in Mumbai, there's something called as probate bench where the last will needs to be certified as a probate. And all the heirs are supposed to give no objection to it. Now, if they don't, it becomes a civil suit and long drawn process. Hence, I'm saying that, if something as a financial needs are required to be met with the very next day, a trust is a better structure. Through trust, you can have two different people. One who is a caregiver, one who is emotionally attached to that special need person, adult or child. And the other who is a trustee, who would be far more financially vigilant. He can be trusted with whatever amount, who will keep on pumping sufficient money to the caregiver such that the lifestyle expenses of that special child is being taken care of and the ecosystem around it is to be created. I think there are parents who are creating these ecosystems together at south of Mumbai, south of India, or multiple such places. I have been visiting such places on and off. So I believe selecting such place in time is important, depending upon what special needs. There are autisms, there are different types of special needs. So depending upon, again, it's a situation specific where in some cases there could be a solution, some cases it would need a customized solution.
Okay. Thor.
So I would just like to add, I agree with Rajesh Bhai that you can't put a 40-page trust deed into a 3-page will. So Rajesh Bhai, we prefer a hybrid. You make the trust today and you can keep adding assets to the trust. You don't have to put everything that you want to put into the trust on day one. First, you make the trust, you put some money into it, test the trust, see how you like it. Then over the period, you keep adding assets to the trust. And of course, in your will, again, you can add assets through will into the same trust. So you have a hybrid. Create the trust today, add assets over a period of time, and also something can come through the will. So that is the best, we feel, is the best way to, create the trust structure so that there is some time over which you will test it before you put more assets into it.
Correct. Okay. Rajat Bhai, coming to this Cooperative Society and the amendment in 2019 Maharashtra Cooperative Societies Act. So status of the nominee, which I made a mention about it, but however, you have some view about on that legal and beneficial. So maybe the share certificate as well as the real estate property.
Yeah. So immovable property is governed by Properties Act, which does not recognize the concept of nomination. However, the share certificate which represents that particular asset in case of a cooperative society is the movable part of the immovable property. It is governed as a security, and hence as per Securities Act, it is attracted to the word nomination and recognizes it. So in Dinesh Bhai's earlier presentation, he rightly said nomination, and he touched upon the word cooperative society. And I would like to add to him that we have normal clients coming and said that me and my spouse have jointly owned the property. Should I make 2 nomination forms or should I make 1 nomination?
Correct.
Now, the fact that you have to make nomination, there is no going back from it. But if you understand that you are joint and your interest also should go to maybe 1 child or 2 child or whoever it is, you should make only one nomination form signed by both the joint holders or 3 joint holders, and appoint maximum 2 or 3 nominees and give their percentages. That's point number 1. But this is only for the share certificate, full stop. Means if one of the owner or sole owner or both the joint holders die or one of the joint holders die, in the share certificate in front of the person who is deceased, they will delete his name and put the name or names as nominee so and so. And that makes that person eligible to become a member. What is the right of a member? He or she just attends the meetings representing the original owner, and that's about it. So here I want to tell you that in a cooperative society or a condominium, please remember there are 3 aspects. One is membership, second is nomination as per share certificate, and third is the only ownership as per the share deed, sale deed or agreement to sale or transfer deed which you have signed in sub-registrar's office. With that nomination form, you cannot sell that property. With the share certificate, you cannot sell the property. However, many people in the city of Bombay and Maharashtra have been depending upon a circular 159B or 13 or 12 or something, on the basis of which it says that you need to take any of the following things, which says probate, letter of administration, succession, heirship, and also mentions a nominee as a nomination form. But if you see the nomenclature of everything, it has all the attributes of that of a share certificate and nothing to that of the sale deed or the real estate. So logically, yes, you must have a nomination. There is no 2 ways about it. But don't believe that just because you have a nomination, you are the nominee becomes the owner and you can sell it. Nominee for all practical purposes is only a custodian or a warehouse keeper.
So now the word they have used is provisional member.
Yeah, right.
So where does that provisional member come? Basically,
Yes.
in the share certificate, does the society have to write?
No, he will write nominee Rajat so-and-so. But what is provisional member? A management committee can only write that because management committee only controls that share certificate. And provisional member is a member till the original heir becomes the member to represent the original heir or owner to attend the meetings. So I will give you another example. I have given my flat on rent to somebody. Sometimes I make the tenant as a member by giving just 100 rupees fee. Does not mean that tenant becomes the owner. He only attends the meeting of the management of the
This you're talking about is an associate member.
associate member.
Okay.
So this provisional member, associate member, these are nomenclatures to give flexibility to be aware of what's happening. Because most of the time in Bombay, people own assets and are not staying in Bombay or staying abroad.
The only my question is basically how does an outsider know if that person goes to sell off the flat? How does he know okay, this is a temporary, the provisional, it's a provisional nominee or is a final legal heir nominee?
No, sir. The share certificate will show nominee, the word nominee. It does not talk anything on membership. Share certificate will not talk anything on membership.
So that legal process has to be checked up by
Yes,
the
sir.
lawyers
Yes, sir.
only.
Yes, sir.
They have to check it. Yeah, Rajesh bhai.